Hong Kong Stock Exchange Directors Training. Responsibilities of directors of companies listed on the main board of the Hong Kong Stock Exchange. 20. Disclosure of interests under Part 15 SFO. Part 15 of the SFO contains complex provisions requiring substantial shareholders, holders of 5% or more, directors and chief executives to disclose their interests in listed companies. The following is a summary only of the principal provisions relevant to the directors. The directors and chief executive of a listed issuer are required to disclose a. Their interests and short positions in any shares of the listed issuer or its associate corporations, b. Their interests in any debentures of the listed issuer or its associated corporations, and c. Any change in or cessation of any such interest. An associated corporation is defined to include the holding companies and subsidiaries of the listed issuer, subsidiaries of any holding company, and any company in which the listed issuer holds more than 20% of any class of its issued shares. In calculating the number of shares in which a director is interested, he or she must include any interests held by a spouse, children under the age of 18, a company controlled by the director, and a trust. A company will be controlled by a director if the director directly or indirectly controls 1/3 or more of the voting power at general meetings of the company, or if the company or its directors are accustomed to act in accordance with his directions. Directors must also disclose their interests in the underlying shares of equity derivatives. The term equity derivative is defined to include any contract which gives a person rights, options, or interests in respect of the underlying shares. Accordingly, if a director holds any options or warrants giving him the right to acquire shares in the listed issuer, he will be taken to be interested in the underlying shares and must disclose such interests. Generally speaking, a person has a short position in shares if he a. borrows shares under a securities borrowing and lending agreement, or b. holds or issues a financial instrument under which he has a right to require another person to take the underlying shares, or is under an obligation to deliver the underlying shares. Long and short positions must be disclosed separately and cannot be netted off. Where a person is or will become a director or chief executive of a company on its listing on the exchange, he has 10 business days in which to file notice of the following interests. 1. An interest in the shares of the listed issuer or in the shares of an associated corporation. 2. A short position in his shares of the listed issuer or in the shares of an associated corporation. And 3. An interest in debentures of the listed issuer or in the debentures of an associated corporation. A new director of a listed issuer must give notice of the above interests within 10 business days of being appointed as director. Subsequent filings by directors and the chief executive of a listed issuer are required on the occurrence of certain events called relevant events. In the case of interests in shares and any short positions, the relevant events include 1. When a director becomes interested in the shares of the listed issuer or any of its associated corporations, for example, on the grant to the director of share options. 2. When a director ceases to be interested in such shares. 3. When a director enters into a contract to sell any such shares. 4. When a director assigns any right granted to him by the listed issuer to subscribe for such shares. 5. When an associated corporation grants a director a right to subscribe for shares in the associated corporation, or the director exercises or assigns such rights. 6. When the nature of the director's interest changes, for example, on the exercise of an option. 7. When a director comes to have or ceases to have a short position in the shares of the listed issuer, or in the shares of an associated corporation. 8. If a director has an interest or a short position in the shares of the listed issuer or in the shares of an associated corporation at the time when he becomes a director or chief executive of the listed issuer. And 9. If a director has an interest or a short position in the shares of an associated corporation at the time when it becomes an associated corporation. Notice of the relevant events at 1 to 7 above must be filed with the listed issuer and the exchange within 3 business days after the relevant event. Notice of the relevant events at 8 and 9 above must be filed within 10 business days after the relevant event. Failure to make proper and timely disclosure as required by Part 15 is a criminal offence which carries a maximum penalty of a fine of 100,000 Hong Kong dollars and imprisonment of up to 2 years. The listed issuer also has a duty to keep registers of a. the interests and short positions of its substantial shareholders, i.e. holders of 5% or more of any class of voting shares. B. the interests and short positions of its directors and chief executive in the shares of the listed issuer and its associated corporations. C. the interests of its directors and chief executive in the debentures of the listed issuer and its associated corporations. These registers must be kept either at the registered address of the listed issuer or at the place where the register of shareholders is kept. When the issuer receives a notice in the prescribed form, it must enter the information on the form in the register within 3 business days after it is received. The interests in the short positions of a listed issuer's directors and chief executives in the shares, underlying shares and debentures of the company and its associated corporations must also be disclosed in the company's annual reports and half-year reports. Due to the complexity of the provisions concerning disclosure of interests under the SFO, only the basic requirements have been dealt with. Further information is set out in the SFC's outline of Part 15 of the Securities and Futures Ordinance. The directors of a listed issuer should consult its professional advisors before making any disclosure.